Thanks very much. Uh, I am indeed the Director of Health Policy at the Office of the Information Privacy Commissioner of Ontario. Um, uh, I wanted to begin with a quick disclaimer and explanation of what that means. Part of the IPC's mandate is an administrative tribunal to deal with the enforcement of laws, including the Personal Health Information Protection Act. I'm not on that side of things. I'm on the policy side, where we do have actually an educational role, and we do produce guidance for different sectors dealing with interaction with Ontario's information legislation. Um, and so what that means is the IPC never endorses or approves any particular course of action when I talk to you like this, and I cannot bind the tribunal. If you're looking for legal advice, I suggest you go see a lawyer. I'm not a lawyer, and even if I were, my mandate would forbid me from providing that. So I wanted to make that clear, that when I say this, if someone complains to the tribunal about what is happening with their personal health information, whatever I'm saying here won't actually affect their deliberations at all. So please do keep that in mind. With that said, though, we do have a mandate to an educational mandate, a guidance mandate, in particular because information legislation is quite complex. I've been in this role now for 1.5 years. I started in August 2022, and prior to that, I was at the Ministry of Health, where I was in the information management strategy and policy branch. Prior to that, I had various other roles in mostly in the university sector. So with that, I actually do have a PowerPoint to provide to you as I talk. I'm happy to take questions, but I also know that when I'm giving the presentation, I probably won't see if hands are up or anything like that. So please just sort of cut in as the case may be. So I'm going to sort of begin and go through some of this. So I'm mostly going to talk about PHIPA because that's what I know, and because I don't know the ins and outs of your organization, obviously I won't be able to speak definitively about some of these matters, but I hope I can assist through the answering questions. I gave you the disclaimer already about who I am and my role, and I will be running through some of the legislative intent behind PHIPA and some of the key concepts that I think, based on our earlier conversation on this topic, what I think would be probably most valuable for you. So the first is really around the fundamental purpose of PHIPA, and a lot of people really do get this wrong. Section 1 of PHIPA outlines the 5 stated purposes, but I'm going to concentrate particularly on the first one, but the others are important as well, in particular because one of the things that I encounter, and maybe it's just that I've been doing this kind of work for a number of years now, but many individuals don't seem to know that they actually do have a right of access to their own personal health information. It was enshrined in 2004 in PHIPA, but it existed prior to that as well. So there are some minor limited exceptions there, but parts 4 and 5 are really around what the IPC's tribunal does. But part 1 here, the first stated purpose, is and I can't emphasize this enough, it's a dual co-equal purpose around what's supposed to happen with personal health information. And on the one hand, it's around the protection of privacy. When you provide your personal health information, it's particularly sensitive, and you have a right to have that information shared in a limited basis and for the purposes for which it's collected. So that protection is there. On the other hand, a dual co-equal purposes around the facilitation of the provision of care. And there are a lot of elements in the legislation that exist in PHIPA that don't exist in other federal or provincial legislation around how that works, how consent for the collection, use, and disclosure of personal health information works, and what it means in practice and why it's written that way. So a lot of people think of PHIPA exclusively as privacy legislation, but it's actually not that. It's also meant to be enabling and simplifying for the purposes of providing healthcare, and I'll get into that more in a little while. So there are some key points here that I'd like just quickly to run through. Personal health information itself is, it includes oral or recorded form. So if I were to tell you I have a broken leg right now, and you were a caregiver, that would constitute the transmission of personal health information, right? Physical or mental health relates to the provision of care, and so on and so forth. The One of the things that fascinates me about this definition is the health number is actually a part of the one element of what constitutes personal health information. So your health number, even though it's purely for the administration of a health insurance system, is in fact personal health information. Of course, with that, and this is obviously in the care context, you might have health information about yourself that never enters the health system, especially with the advent of wearables like Fitbit or Apple Watch or whatever that monitor your heart rate or so on. Even though it is health information about your person, it's not PHI in the sense of the law, because the law applies to really what happens in the health system as opposed to your own personal matter. So it's not aggregated information. Like if you say that, if we hear that there are so many thousand cancer treatments happening in Ontario in any given month, that's not PHI. If de-identification is not PHI, de-identified information. Information unrelated to healthcare that a caregiver might have, such as, for example, a hospitals often operate parking lots and charge for parking, not personal health information. All that system, their HR systems to deal with payment, hiring and payment of staff, not personal health information, even though they're held by caregivers, right? But there is something here that's called the mixed record rule, which is, if you give me your name and birth date, that's just what's called personal information. But if you give me your name, birth date, and health card number, that is personal health information and therefore governed by the Act. So if you start mixing information in with personal health information, what it means is it all becomes personal health information. And the other thing is, it's health information custodians, basically custody and control of information in terms of performing their duties. That's healthcare providers. The Ministry of Health, because it operates the health insurance system, is one. Home care provider organizations, hospitals, long-term care homes, retirement homes, pharmacies, labs, so on and so forth. Things that organizations that collect, use, and disclose personal health information in order to either administer the system that provides you care or to provide you care. And HICS, as I'll say, health information custodians, HICS have rights under PHIPA but they also have obligations, and a lot of people often think that those obligations are onerous, but they are really meant to be ultimately protective and set out clear rules for collection, use, and disclosure of personal health information. From conversations leading up to this, I understand that this is where a lot of the conversation will be focused, but PHIPA is consent-based. And I mentioned before that there are matters that are there to facilitate the transmission of information for care. So the most obvious form of consent is express consent. That means, typically I will say, I give you permission to do this, and I might even sign a form to allow you to collect, use, or disclose my personal health information for a particular purpose. That is absolutely legally appropriate, and it has certain advantages. It gives clear rules on what is allowed, and by extension what's not. And it also is it mitigates risks around liability. That is, no, you sign this form that says we can do this, right? So, but it has disadvantages as well. I'll give you one example that's unrelated to this field, but what used to be the Trillium Gift of Life Network used an express consent form for their work that said, and we will absolutely not use it for anything except these purposes. And yet the data that they hold is actually kind of important for system analysis and so on, but that's expressly forbidden by the consent form. Even if they didn't have that, they would have been able to, analyze the effectiveness of their program, but they promised they wouldn't use that information for anything except the program purposes itself. Express consent is also difficult to manage and document, especially dynamically, and also there's a lack of understanding frequently from both providers and patients really around what express consent means in practice and how, and whether it can be withdrawn and so on and so forth. But PHIPA also allows for two other forms of consent for the purposes of care, or I guess it's a variation on one form, but implied and assumed implied consent allows for the collection, use, and disclosure of PHI for healthcare purposes without having to ask for express consent. And that's really to enable that dual purpose I talked about before. So what that means is when you call your family doctor's office, they can pull your file without you having to say, I now give you permission to pull my file. And they can look at the file and they can prepare for the appointment without you having to provide express consent. You really, by calling, you're implying that they have consent to collect, use, and disclose your personal health information in order to provide you care. And assumed implied consent similarly is where if, for example, your family doctor refers you to a specialist, and unless you say, no, don't share the information, that specialist can assume, even though no one has even presented themselves, that they have implied consent to provide healthcare services. So this is obviously, it would be a massive administrative burden if we sought express consent for every interaction anyone had with the healthcare system around information. So it is easy to use, and it actually does allow for straightforward collection, use, and disclosure among providers within the circle of care without having to seek express consent. Now, it is still consent-based, so you can actually say, no, I don't want you to disclose that information, and that's what that's someone's right. But unless that instruction exists, then you can assume that there is consent to collect, use, and disclose for the purposes of providing for providing healthcare. And that means that if you're in a hospital being treated by a team that would include, for example, a lab technician, an imaging specialist, a doctor, and a team of nurses, theoretically, they are all trying to provide you care in conjunction with each other. So they can, they can collect, use, and disclose personal health information and share it among themselves to provide care. Disadvantages here, really, it's only for care. And consent can be withdrawn, and you're not allowed to use it if consent has been withdrawn. And that's a disadvantage. The other thing is that if express consent may actually override the ability to use implied consent or assumed implied consent if it's done in such a way that indicates that that's all that will happen, as I mentioned before. And this is another concept that I think is really important for someone in your role, from what I understand, and it's really around what an agent is. And so that's a person, and that can mean a corporation as well as a physical person, with the authorization of the custodian, acts on the custodian's behalf. And so what that means is if I if there's a hospital, a doctor or a nurse in that hospital would be an agent. They're not responsible for collection, use, and disclosure of that personal health information. The hospital is, but they can use it in a way. They can provide you care. They can do that. Another example might be so. It just so happens that the Ministry of Health is the custodian of the Ontario Lab Information System. So lab tests typically are in the custody of the Ministry of Health. The Ministry of Health, and I say this from my own personal experience from an earlier life, the Ministry of Health does not operate the lab information system. Ontario Health does, on behalf of the ministry. The Ontario Health is the ministry's agent. But what that means is that without an agreement, Ontario Health has no particular rights over that information other than to do what the ministry says, right? And so what that means is an agent doesn't have independent rights to collect, use, or disclose. So if you're an agent, it doesn't mean you can necessarily turn around and use that information for your own purposes. You're an extension of that caregiver's or administrator's kind of like rights. So when you're at a hospital and an agent, like a doctor, opens up an electronic medical record system and looks up a person, that's not under law a collection of information, because it's just like it's been collected already, and that doctor is just using it. And accountability for agency rests with the custodian. So that means, again, I'll use the hospital example because it's an obvious one. In that hospital will be accountable for what happens with that personal health information, and so that means they have to train that doctor. They have to make sure that the doctor's following their rules. They have to have rules in place around. No, it doesn't mean you can walk away with this information. It doesn't mean you can do other things with that information without it applying to the same rules as any other custodian under PHIPA. And I'll get into that in a bit. So the IPC typically recommends that in agent arrangements that relationship be clearly understood and wherever possible documented. That is through something called an agent agreement. That is, you have the rights to do this, this, and this, and you agree not to do anything outside what we're telling you to do. That's a sort of typical structure of an agent agreement. I wanted to before I open it up for questions, I also wanted to talk about what that actually means in practice. So I've mentioned the words consent, use, and disclosure, and PHIPA has actually quite a bit about each of those three things. So collection, obviously, done with consent by providers, and there's also indirect collection can occur if you say, oh yeah, I want to collect other information about you to provide you care, and you can go to, I don't know, like you could conceivably go to my parents to talk about what health issues I had as a child that I might not remember, right? With express consent, I could do that. Reasonably necessary for care and not reasonably possible to collect directly when it's necessary for a statutory function of an institution, research, prescribed entities under Section 45. If my boss, the commissioner, says it's all right to collect information indirectly, you may, whether it's required by treaty, etc. So also, if I'm unconscious in an emergency ward and I'm not capable of consenting, you can collect in order to provide me health care, and if I need that care right now because otherwise I'll bleed out or whatever, you don't have to wait for me to give consent. And there are some things that are done without consent, right? We have a public health insurance system, and in order to run that insurance system, that means that the health number has to move around, and in order to payment, etc., that kind of thing. So that's really, I mean, collections in Section 36 of PHIPA, and that's really what it's for. It's meant, the primary purpose of collection is really for either healthcare or administering the healthcare system. There are some exceptions to that, but not many. Section 37 of PHIPA is around use, and you're all within the broader healthcare system, so I don't need to make this point quite as stringently, but PHIPA, unlike the Freedom of Information Protection and Privacy Act or other or federal law like the Personal Information Protection and Electronic Documents Act, or federally, or other laws around information collection. Actually, normally the rule there is that you can only use the information for the purposes for which it was collected and other very limited purposes. By contrast, PHIPA actually allows a pretty broad range of uses by a custodian for once that information is collected and care is given. So, planning or delivering programs provided by that HIC, or allocation of resources within that HIC, or evaluating those programs, or detecting, monitoring, or preventing fraud or unauthorized risk management, error management, quality improvement, education. Hospitals many hospitals are teaching hospitals where, strictly speaking, a group of medical students on rounds, that's expressly allowed here as a use of health information. You're allowed to use it in order to seek consent about something. Obviously used for proceedings or contemplated proceedings, obtaining payments, research, unless otherwise not allowed, and if it's allowed under law. So there's actually a pretty broad range of uses that custodians are allowed to get into. And lastly, I want to talk quickly about disclosure, because that's actually a huge section, and that's probably where I spend a lot of my time thinking about it. But there are a lot of possible disclosures around of healthcare as defined by legislation, and some of them are actually pretty important. So obviously you can disclose for healthcare. That's the circle of care I talked about. For health or other programs, including to something called prescribed registries, which are registries for the provision of care that are listed in legislative regulation. Risks, proceedings to a successor, including to archives, so that you can disclose if you're retiring, you've run a clinic for a long time, but someone else is taking over the clinic, you can disclose it to your successor, even though it's not yours anymore. Disclosure, PHIPA has a bunch of internal disclosures allowed, like the commissioner needs to investigate, disclosure is allowed for that. For research, for planning and management of the health system. So there are 4 things called prescribed entities in Ontario that are listed in regulation. That's Canadian Institute of Health Information, Ontario Health in its guise is the former Cancer Care Ontario, the Institute for Clinical Evaluative Sciences, and the Pediatric Oncology Group of Ontario are these prescribed entities that are around planning and management of the system as a whole. Mandatory disclosure for health payments, analysis of the health system with the commissioner's approval again, and you're also under certain circumstances allowed to disclose outside Ontario. Just a couple of quick points before I wrap up. There is something called the data minimization principle. Most people don't know it as such, but sort of intuitively know it. You can't collect, use, or disclose more information than you actually need to. That's a part of the protection. That is, you don't need my entire medical history to treat a broken ankle. Like you might need to know if other things about that, but not that. Disclosures are mostly mandatory. There are some exceptions, but there's not a requirement to disclose in most cases. The custodian can choose not to. Some disclosures can be made without consent. So I mentioned both the prescribed registries and prescribed entities. You do not have to tell individuals that their personal health information is going to these organizations. And that disclosure for research actually does have additional elements of scrutiny around, like research plan, research ethics board approval, statement of anticipated benefit, whether whether those the objectives of the research plan could be met without the PHI, whether there are safeguards in place, et cetera, that kind of thing. And I have mentioned these two things: prescribed registries and prescribed entities. So this is just a bit of background here, and I think this is one of the things that, in terms of just, if I can get personal for a second about my own work, this is one of the things that I think is probably not well understood broadly in the population, that there is actually pretty significant disclosure of PHI for good reason to these organizations that are listed here. And one of the reasons I think that's important is, you may have heard last year, the Children's Hospital of Eastern Ontario, which operates the Better Outcomes Registry Network, which is a registry of newborns and maternal and newborn personal health information. They used a tool called MoveIt to transfer files, what they thought was securely, but there was a day zero vulnerability in MoveIt, and years of birth-related information was breached, and that was, we've received complaints here at the IPC around why does, people from Windsor saying, why does the hospital in Ottawa have information related to the birth of my son 10 years ago, kind of thing, right? Like, and that's that is one of the real risks for that. So one of the things that is meant to reduce that risk is, every 3 years, these organizations that obtain information without consent have to undergo a pretty thorough review by my office of their practices, policies, and procedures, to ensure that they're trying to do that they're protecting privacy appropriately, that they're and that they have in place all the appropriate measures, privacy and security measures, as well as governance measures to deal with that. So I'm going to wrap up there, because I know there are probably a bunch of questions, but I will be providing this slide deck, and my email is there if you have sort of additional questions and so on. Although I'm located in downtown Toronto, this is a province-wide mandate, the commissioners and officer of the legislature. So I'm happy to hear from across the province on that. So with that, I'm going to stop sharing, and I'll happily open up for to questions. Thank you.
Thank you, Andrew. That was really quite informative. I do encourage everyone to ask questions. I know when I spoke to you, I think it was 90% questions, and I'm glad I took that opportunity, because a lot of what we do is very nuanced and case by case, and it is nice to be able to get the clarity on those things. So I think maybe we could do the raised hand feature, or or you could put your questions in the chat, and then I'll moderate and kind of, or Andrew, if you want to check them yourself, and we can answer them one at a time. Is there anyone who wants to ask a verbal question over audio? I know when we talked about this in the weekly meetings, there was a lot of questions and a lot of back and forth. David?
Andrew, I've got a client, let's say for 3 years, working with me, and all the information, the talks are listed or recorded online. And the client moves to York region. What can or cannot or can't I send to York of everything that I've got? Can I send the whole package to York? You're muted.
It really depends on, and this is something that I don't want to misspeak here, because I'm not sure what status you have, but whether you're an agent of a custodian, whether you're a custodian yourself, whether you're sort of attached to the health system but not part of it. I think that's all sort of relevant here. And if you're in the circle of care, and so is the in York region, where the person has moved to, there should not be a problem with sending the entire package of information over for that person's care. Really, it's one of the sort of what I was trying to get at in the dual purposes. Look, if I'm that patient, do I have to say now, please transfer my file over? And no, to protect your privacy, we won't. I mean, that's it is a voluntary disclosure to the receiving organization. That's what I was talking about in the disclosure part there. Most is voluntary, but if it's a custodian or an agent of a custodian to another custodian or agent of custodian, then that should be, unless there's a directive not to do so, that should be quite possible.
That directive would come from the client, correct?
Sorry?
That directive comes from the client, correct?
Yeah, I mean, it can come from, yeah, the directive can come from the client if it's not to do so. Otherwise, you can probably assume consent to do so, right? So one of the things that causes delay in the health system broadly is if someone is referred to a specialist or to a different doctor who might or a different provider, that information, might not follow properly, right? So, you hear stories about someone getting the same lab test 4 times as they move through a different organizations because they want to be sure they don't have the proper information, or that kind of thing can keep happening. So if it's for care and there is no such directive, it's probably possible to share without getting express consent to do so. Recognizing that I don't know exactly what relationship your organizations would have with the provision of care.
I can add a little clarity to that. So David is the executive director of the epilepsy agency in the Peel region. Mm-hmm. And the example he was giving was to transfer a patient file over to York for the purposes of continuing care, okay, which would be a separate legal agency.
Yeah. If it's for care, then that's the legislation and the policy is meant to facilitate that, really.
Yeah, so that's okay. So then in that case, it'd be okay to move the patient's information from Peel to York for the purpose of that person continuing their care.
Yeah. If you were to do it for fundraising, I would say no, don't do that. That's a bad idea. But if it's for providing care, yeah, it's how does it help someone for to protect this person's privacy? We won't will make life harder for them at the other end. That's not what's meant to happen.
Yeah. Is there anyone else with a question, or David, do you have a follow-up with that?
I pretty much answered it.
Yeah,
sorry.
No, go ahead, David.
I was gonna say that pretty much answers the question. I know that question's been brought up before in our meetings, and about what can be transferred, what can't go. If it's for patient care, that's great. Thank you.
I guess, sorry, I just want to clarify for my own sake, in terms of what we do in terms of education and support, etc. And we gather personal information, but I want to I guess I need clarity from you, and maybe this is a dumb question, about where are we in the circle of care? Are we just kind of an add-on? I mean, we get referrals from the neurologist, but we also get people just calling us, etc. So I just feel like I need to get clarity on, are we in the circle of care? Are we an agent? Where are we?
That's not a dumb question at all. I'm not sure I'm the person to answer that, really. Like that's, I mean, but that's really, I think that's the answer to that is really, really key. Like if you're being referred to, if people are referring if organizations are referring people to you for care, pardon me, then that sounds as though you're in the circle of care. Yes, that I mean, I can't speak definitively about what that might constitute in practice because I don't know your organizations, but yeah, I think that's really key. So are you delivering care on behalf of another organization? Then you're an agent. Are you delivering care independently? Then you're a custodian. If you know that's really what you have to know what your role is, and I can't speak to that. But I mean, it is really important to have clarity on that. I see there are some questions in the chat, and transferred via regular email. So this is a security, not a privacy question, so I can't answer definitively. It would be better to do so through some kind of secure portal system. Email security is better than it used to be, but that's I'm afraid I'm not a tech person and don't know fully the answer to that. I mean, really, I think if you're going to send something through regular email, you actually probably should go to the patient and say, I would like to send this by regular email. There may be a security risk. Are you okay with that? Email, you know, what the risks are lower than they used to be. Email delivery companies are, it's not sort of open traffic the way it was sort of 10 years ago. But
Andrew,
yeah.
Sorry, with the new shared database we have coming on board, we have the ability to transfer information between agencies all within the database. So David and Peel could just move that record over and give access to that record directly to York. That's very different, correct?
Yeah, that would be probably preferable. I mean, that system would still have to have all the appropriate security measures, et cetera, et cetera. But yeah, that is much preferable than sending by email as a general rule.
Yeah, so those that are going to be onboarding in Apricot, which is 100% of the agencies, do know that we have the ability to transfer that information internally in a much more secure way and faster way than email.
Yeah. Now there are potential disadvantages, and it will be really important to train both yourselves and people who are using this system that snooping is in fact a violation. If just like, ooh, that looks interesting, looking up people, or oh, how's that person who used to be in my care doing? That's inappropriate. That's not allowed. That would be considered a breach. And I mean, I know that this is probably the moment for most of you, but you'd be shocked how many people, even well-meaning people, really kind of violating people's privacy expectations because it's technically easy to do so, and that's really not appropriate. So, sorry, I just saw the word fax show up. No, fax is worse. Don't do fax. If you have looked at if you've looked at anything that my commissioner has said over the last few years, she wants faxes removed from the health system entirely. They cause more breaches and more pain than almost anything else. We're trying to get rid of faxes altogether. The health system is the only place where fax machines are still used in large numbers. Please don't use faxes. In terms of Rosie's, I know. Oh yes, I know, Rosie.
I think that's a follow-up to David's question about interagency transfers.
Yeah. So Rosie's question around discussing with the client. Yes, it's always better for the client to be informed in general about what's going to happen. It's like, I'm now going to refer you to this other organization, and they'll be able to take care. You can get there. You can certainly. It's better for individuals to be informed about what's going on. I think sometimes that's not possible, and sometimes people are gone, sometimes it's very difficult, so you don't need to seek express consent. But to take that example before of someone moving from Peel to York, they say, okay, so I'm going to transfer you over to your new locality, and I'm assuming you're okay with this, but speak now, kind of thing, right? So you know, I think it is better to keep people informed. What I'm talking about here is in general, you know, the legal authority versus, you know, what you should do in terms of dealing with people as human beings with, you know, their own emotional lives and so on and so forth. Right. Oh God. ODSP. I'm sorry. Okay. At this point, this is one of those. I will not tell the commissioner what is being said on this chat because I think she would probably lose her mind. Oh, faxes are great. Yeah, she really does not want that. She in fact sponsored a national resolution around getting rid of faxes in the you know, across the country in the health sector. So.
Dave, or sorry, Jeff.
I really like what you say about making it common practice to talk to your clients about what you intend to do and to get their permission, because it's sort of it should be part of standard fare. You made reference a couple things. You made reference to an oral contract as well as a written contract. So you're talking to a client, say, "This is what I'm going to do." They say, "Sure, go ahead." How do you record that? So when they turn around and said, "I never told you to do that. You shouldn't have done that."
This I'm okay. So first of all, I'm hesitant to talk about this as being contract law because it's
Okay.
not. But and I'm not a lawyer either. So, but I think well, I can tell you one case. It occurred actually in Ottawa a number of years ago, where someone went in for care and gave permission to override a consent directive to look at that, so that caregiver could access personal health information, and then forgotten that the permission was granted and complained to the Information and Privacy Commissioner that did an investigation, and basically it became a provider's word against, and the investigation happened, and there were multiple witnesses at the no, this person made the appointment, this person went into the appointment, they clicked a little note saying consent granted, they wrote in their notes, they like that kind of thing tended to override someone's, you know, memory about, I mean, in the end this person had sadly forgotten that they had even been there. So this is in a system where consent and it is a risk. I mean, I'm not going to lie to you that, you know, people do forget. People forget they have consent directives, let alone that they can override them temporarily. You know, that's so.
And Andrew, didn't you say that the minimum standard is implied consent to deliver care?
Yeah, for
And,
care, yes.
and
Yeah.
unless the client expressly
Yeah.
declines that.
Yes.
So you would also have that to fall back on in a case
Yeah.
like where you have a verbal express and it
Yeah.
then they complain, you still have implied consent to fall back on, do you not?
Well, yeah, I mean, that would be if the consent I mean, if you have a clear consent directive at like saying do not do this, and then you ask for permission to do that, that's where I actually probably would bust out a form and say, okay, you have this directive, you are giving me permission, right? Like it shouldn't get to the point of that unless there's a pre-existing directive, in which case I'd probably say the better thing to do would be to have like a note saying I authorize this transfer kind of thing.
Yeah, but in most normal situations, you do have implied consent for the purposes of delivering care. And
yeah.
if you want to go above and beyond for the express consent, you can. So there's some protections and
Yeah, you can, but it's important to yes, you can absolutely always go to express consent. It's a higher level of consent.
Yeah.
In a perfect world where everybody had tons of time and loads of resources, express consent would be a better way to do things in general, where people could understand what's going. The reality is, and I hesitate to say this, but a lot of people do not know that the range of their rights over their personal health information. They do not know they have access rights to it. So this is really meant to, a lot of this happens to protect them, you know, in the absence of that sort of detailed knowledge. I mean, I and many of you spend an inordinate portion of your lives thinking about exactly this matter. The vast majority of the population spends precisely no time doing that, and so I think we've got to be. I mean, that it's really incumbent upon us to make sure that their information is handled in a way that is ultimately, ultimately it's an ethical question more than a legal one to me anyway.
Right.
So
Andrew, I'd like to ask a follow-up, and then I know Sandra has a question, but when we had talked, you said, if there comes down to there's a complaint or a concern, can you talk a little bit about how the IPC handles those? So if people are worried that the client does complain, you had given me some guidance that you look to how the agencies are handling or their intent, and so how would that be handled if there were a complaint?
yeah, so we're not we don't go out and seek wrongdoing, or it is a complaint-based process. So we'd have to receive a complaint, and the vast majority of our resolutions, and in this case, Canada is pretty different from the United States in terms of how information law is enforced. If someone's doing something wrong, typically we would say, okay, well, maybe, in the future do this. Like we don't, the idea is to get to compliance, not to punish mistakes, right? So that's I'll give you an example. As of January 1st this year, under PHIPA, our office now has the authority to administer or to levy administrative monetary penalties in quite high amounts. We anticipate that will be under 1% of our PHIPA cases, because it's not. There's no point in people paying for a misunderstanding where something is pretty minor. Like normally what we end up doing is change your processes so that it does this. That would be the kind of thing, and most people are pretty responsive to that. So there is I mean, the tribunal side of my organization is a quasi-judicial tribunal under the law, and it can investigate, it can adjudicate. We have a mediation department that hopefully gets rid of a lot of that early on. The investigation, there's an early resolution area that most cases deal with. It's like, okay, here's how to resolve this, and don't do that again, or maybe delete that information was transferred inappropriately. Please delete it, receiving organization. Or this person wants to put in a consent directive, so to make sure this doesn't happen again. That kind of thing is usually the way we want to. So the commissioner herself wants to, her catchphrase is that we want to be a modern and effective regulator, and that does not mean being so rule bound that any minor, like most problems that we face are actually quite minor and not intended, and it's well-meaning people trying to do the right thing. And I think that's sort of, people acting in good faith, trying to do the right thing who might have made a mistake is, let's correct the mistake. So one of the analogy the commissioner likes to use is in the hospital sector, there's something called a just culture approach, where for medical care, a mistake, even if it's something that has a bad outcome, is corrected. A sort of inappropriate, like, behavior that might be too risky is coached, and reckless behavior is punished, right? And that's sort of how, and it's more important about the behavior than about the outcome of that. So, and that's really what we're looking for, which is why snooping is endemic in the health system, and it's terrible. And that's the sort of thing that we would take a more kind of like order-based, I don't want to say punishment, but corrective-based approach versus a mistake where someone, whoops, I accidentally, if someone sends something by email, it's like, don't, we're not going to say, how dare you? We're going to say, you know, did you consider that the email was secure? Maybe don't do that. You've got this, you know, you've got this portal system, you've got this other system that is better for sharing information, more secure and less private and more privacy protective, et cetera, right? So that's the kind of, as a general approach, we don't want to be out there. Like we're looking for compliance with standards rather than punishment.
So Andrew, we have a couple of questions in the chat. One is about getting express consent to contact a school. And the second part of that question is related to how long are consents good for? Do they expire? And then Rosie's added on to that, saying that she's in our RSW, I think, Rosie, and that they've given them some guidelines to include a timeline within those consents for expiry. Can you comment both on the sharing of information or not sharing of information, contacting a school, and the timelines of which consent, whether it's express or implied, may have limitations?
So there are, on the contacting the school, typically schools are not healthcare providers, so you should get express consent for that. I mean, there are some cases where you don't need consent and you need to contact the school under law, but I don't know exactly what those are. I know they exist, but there are cases where if there's, for example, an overriding safety issue, you know, when years ago when I was at the University of Alberta, there was a student who was trying desperately not to listen to the voices and had serious mental health issues that could have resulted in harm, and you know, that was one of those. We're disclosing the information publicly, basically, because it's for everyone's safety. Like that's a typical override of privacy when there's you know, strong evidence to suggest that. I don't know the ins and outs, but because a school is not a healthcare provider, I mean, there may be other cases, there may be things in the Education Act that I probably don't know about, but you should get express consent in most cases like that, and be aware of when consent isn't required at all. On expiry of consent directives, sometimes it's you know, a one-time thing. Do I have permission to transfer this information to, you know, to this other organization? Yes or no. Then it's done. If it's an ongoing sort of every month I'm going to send this, you should probably include an expiry in that kind of express consent. The memory issues, that's probably a sensible thing where if someone doesn't remember, that's in the health system, that's especially for elder care, that's a constant risk. And you know, it's you know, it really, it's very, very situational dependent, and it's when you use express consent, most of it, usually it's done, if it's not required, it should normally be done to protect both the organization doing the disclosure and the patient as well. And that, you know, it's really about, consent is around ultimately the protection of that patient. And so I think I can't speak definitively about any of this, but it really should be, you know, what's best in the circumstances to do this. How long do you really need to do this? What's going on? If it, you know, that the minimization principle still should apply in all cases. So, you know, even if there is something that's done wrong, it should be minimized to the bare data that the other organization that they thought it should be needed. So there are a lot of controls you can put on that, but without knowing circumstances, I can't really speak definitively.
And I think we have a raised hand here from Ann Chugan. I apologize if I got that wrong.
No worries.
We haven't met, but nice to meet you. I hope I didn't do too bad of a job of your name.
No, you got on point. Hi, everyone. Thanks for the information. I think my question is a bit of with Andrew and Paul. Number one, because I guess for us, whenever we do work with clients, we always upfront talk about consent, because that's part of our college. We talk about the consent piece and let them know right from the get-go what consent will look like, but also, if need be, get them to sign a release of information if in an event we need to speak with someone outside, like a doctor or someone. So everything is done through consent, and they're well informed. However, you did talk about something, Andrew, that I want to go back to when you said, because we collect personal information like name, date of birth, address. However, the key point you pointed out was health card numbers. And I'm just curious, because I'm not sure if in our new database, if other regions are collecting health card numbers, which would then go towards your mixed information context, and if that would now change things if other regions are adding health card numbers to their profiles or demographics.
I can answer that in the software. The software does not currently collect health card information.
So it does not?
Right, the new Apricot system does not currently collect health card information. If it needed to be, if we needed to, we could, but then we would just have to compartmentalize it in a way that protects the privacy.
Okay, great. No, because my question was really around, because if in an event we do end up, like an earlier conversation, a patient or a member of ours moves to another region and we're doing that cross transfer of information, then does that now change that profile as a result of the health card information in terms of like how we're now viewing that particular client's information?
Well, I think Andrew, you could maybe speak to this, but I think you get a couple of different types of scenarios. You have a scenario where the health card information is attached to health information and shared between agencies. You could have a situation where, in which case, Andrew, I think you said that would be mixed data and therefore becomes PHI.
Yeah, it's not just the health number. That was just an example. So I mean, if you have a case file that includes personal health information, the name and address that would attach to that case file would also be personal.
Right.
That's really what's happening. If it's purely just sort of the name and address, we have client A with this, with this name and address. There's, I should be careful how I say this. So there is some indication that, if someone is receiving treatment for epilepsy at one of your organizations, that in and of itself, the fact of your name might be personal health information, right? So because you could reasonably derive that person that person has a particular condition, which is personal health information. So you've got to be careful there.
Okay, thank you.
Anyone else with questions? I'm really enjoying all the questions and the scenarios. It's good. I see Jeff and Rosie both with their hand up. Who would like to go first? Rosie? Okay,
Yeah,
Rosie.
I just want to follow up on something that Anshigan said and what you said earlier, Daryl, in relation to our new database. So for instance, currently, all our clients sign an informed consent when they start services with us, and it sort of explains who has access to their information within the confines of, say, Epilepsy Toronto. So technically, the agency is a custodian of their file. If I drop dead, God forbid, then yeah, someone else should be able to take over. So we sort of include that. So with Apricot being developed the way it is, where maybe more sort of transfer will happen, I suspect, correct me if I'm wrong, that we would need to, are we saying that we need to broaden that consent to include that? Or is it still a question of Epilepsy Toronto owns your information, therefore you would have to sign an additional consent for me to send it to Sandra at Epilepsy Southwestern? Because like I said, and you just said, Andrew, we do collect a lot of health information from patients. And right now, based on our policy or whatever, that it technically, I'm responsible, but ultimately the agency is responsible for that information. Therefore, anyway. Yeah.
So within Apricot, again, it is one shared database. So with different agencies have their own data. And I think what with the internal referral system, I think we agreed that that was the more secure method. And that the minimum standard is implied consent to transfer between agencies. And if you wanted to get express consent above and beyond that, that you could. Did I summarize that reasonably well, or?
Yeah, I think the one thing you should be careful of is what your consent form actually says, and so on. So if the express consent is sort of worded along the line, and again, not a lawyer, don't take this as definitive. You should really talk to other people about this. But if the express consent is definitive, saying we will only do X, Y, and Z with it, then you probably have to seek additional consent. If it's like, welcome, you acknowledge that we are coming in for care and that we will collect, use, and disclose personal health information in line with the Personal Health Information Protection Act. That would probably be general enough to allow you to function on implied consent after that, right? So it's really, it depends what your express consent statement says in that respect.
There's a version where our statement could be so restrictive that we could prevent our clients from getting the treatment they need or slow down that treatment.
Yeah.
If
you had to seek express consent, I mean, so a safety override might occur. Like if someone needed that information right now, you could say, we can't reasonably get consent in order to provide this person care, right? But you've got to be, you've got to be careful that you don't unduly or unnecessarily limit your flexibility with what that means. So somewhat more controversial among some people, but I don't know if you remember when the first wave of COVID vaccines was happening, there would typically be a sign saying this is what's happening, and all you did was acknowledge that you saw the sign, right? Like that's pretty close to implied consent to right there, right? Like it's not it's not the same thing as I give you permission to do X, Y, and Z, but which might also sort of implicitly say, but not STUVW kind of thing, right? So like I mean that's really where I think you'd have to talk to someone who knows both what you do and understands the sort of implications of a particular form. My advice would be to keep that as general as possible in the context of care, because if you're too specific, sorry, I said advice. I'm not giving advice. Sorry, my lawyers would go crazy if I said that. But I think you just have to be careful on that. And really, I mean, where you can, my suggestion would be to, as appropriate, rely on implied consent and assumed implied consent when providing care. That's that's probably easier, and there are all sorts of reasons to, in individual circumstances, to make exceptions. We talked about, people with memory difficulty, where it might be better to record. Oh no, we're doing this, and here's you sign this when that happened. That kind of thing. I get it's. I think the key point is around the facilitation of the provision of care, and what people reasonably would expect. And I think it's not reasonable to expect most people to say, no, actually, I wanted that information to stay over there and for all eternity, and even when I moved, never to fall. Most people don't want that when it's about their own health care, right? And
sorry, Jeff, was your sorry, I don't know if your question was related or different, but do you want to go ahead?
It's a little different. Do you mind if I so really quickly, one of the other comments you made, Andrew, at the earlier when you were sort of just outlining your remarks, had to do with accountability, and I appreciate that the HIC, the custodian of which is the agency that's the custodian of information, has ultimate accountability. How about the individual counselor, the individual staff person? I know that my counseling staff definitely have personal insurance and accountabilities that they have to ascribe to, but I don't know that that's something that everybody on this line generally does. Is there individual accountability?
And well, this is why I sort of said like that, why we recommend actually when like, so those individual counselors would be considered agents under the law of the custodian, right? So what they do with that personal health information, if you don't give them any direction on what they're supposed to be doing, then you know, then that's probably on you. If you say, here's what you're limited to do, even though you as the custodian would be legally accountable, you wouldn't be held responsible because someone else would be violating kind of your rules that they know about, right? And I think in that respect, like that, I think that would probably be where, you know, there's legal accountability and then there's actual like outcome accountability. And I think that'd be one of these cases where, you know, it's entirely possible for one of those agents to go onto this apricot system and look up a relative across the province, right? That would be a violation of that person's, you know, of that. Yeah. And we wouldn't blame the system or the system holder or the organization for someone deliberately violating the rules and doing something that is actually like against the law, right? Like that in that point, real accountability would lie with that agent. But that has to be kind of, you know, documented, or if not documented, then at the very least well understood, and you can say no. And when we hired them, we gave them this training, and every 2 years they receive a refresher, and they now got a part of the training course on this apricot system include statements like this, et cetera, et cetera. I don't know if that's a real answer. That would be my guess as to how I mean, I go sort of what would my colleagues in the tribunal say, and they would have no interest in going after a custodian that did the right thing, but some bad actor is like misusing the system, right?
So we're getting fairly close to our time limit. Are there any more questions from the group?
Okay.
Sorry, people shift. Oh, Mackenzie's got one. Sorry, Mackenzie, you shifted on me real quick.
Sorry. I'm coming from sort of a different perspective in being from the communications. So in general, we don't go into what our system is Penelope, and we likely won't use apricot, but I'm trying to understand the relationship, because when we get a new client, we get an email address and they consent to be on our e-news, so that information goes into our e-news, and that's kind of separate. But then there's like, say there was an instance where we were looking for someone who lives in a particular area. We're looking for a member that lives in the beaches because the beaches wants to do an article on someone. Would it be an infringement of their information to just search for someone in our database in apricot? Like that, we're not allowed to do that because that's their health information, even though it's not their health information, but because it was collected. Like, do we need to collect, basically I'm saying, do we need to collect all the information we need as communications separately and outside of apricot in order to do that?
So you can look up someone's name and contact information for the purposes of contacting them. Like
Okay.
that is an allowable use under section 37. Like I think I have that right. Sorry. Let me just see. Sorry, I'm just looking at my slides. I'm on one screen. Yeah, so for the purposes of seeking consent about something when limited to the contact information to get that consent. So that's a highly limited thing. You're not allowed to sort of, you know, for the case of someone in the beaches, you're not allowed to say, oh, and I'm looking for someone with this, this, and this. It might just be like, we've looked you up to ask you permission to use, like that kind of thing, right?
Okay.
So you would, and then you'd have to go and get permission to do that other thing, right?
Of course, that we would do, but I'm just trying to figure out what I'm even allowed to ask my counselors for.
So I mean, again, like I would say, when doing that kind of thing, you should, you know, seek your own counsel about what that means. Don't take my word for it, because that is one of the things where people can be sensitive, and you have to be aware of what's going on there. And
there is additional legislation that you want to be aware of as well. So Castle Canada anti-spam legislation. If you're not familiar with that, you should look that up. And that has its own set of express implied consents and exceptions as well.
Yeah, and
it's a fun read. I think it's 67 pages. So
it is. It's fun. But I just, I wondered where the crossover, because this is health, but then, So, thanks.
I think if I might jump in, I think, Andrew, maybe this is one of those situations where it's not for delivering care. So express consent is probably
required,
required at a minimum. I don't see any other hands, but I got two screens here. Maybe Andrew, I would really like to, if you could talk a little bit aggregate reporting. So with all our agencies being in one software, we do have the ability to run aggregate type of reporting that says, there's X number of people in this region versus this region in this program or that program, and what are our capabilities to do that?
That's not personal health information as far as I'm concerned. Like, that's it's not personal, right? Like it's health information, but it's sort of like district based or whatever, right? Like it's about really it's around identifiability, right? So there is something called the small cell rule that is context dependent as well. Like if you say, okay, well, in this small town there is one person who fit, like, that's probably identifiable to anyone in that town, right? So that would be probably a violation of privacy. But if you're talking about, there are this many hundred people, can you identify any of them? Probably not, right? So that I don't see a problem with that. I mean, it depends what you're actually looking up, like whether you're generating a report or whether you have to collect everyone's information and go in to generate that report, at which point you should probably, like, that's an allowable use to do that. But if it's going to be a sort of shared use, then you should probably have some kind of like agreement to allow a central person to do that from all the various custodians of that information.
So what level of consent would we require?
You wouldn't. That's an allowable use.
Okay.
That's personal health. Like that's one of the things about the flexibility there, is that it's really it's not just meant to be for care. It's about quality improvement, for detecting fraud, for program improvement, these kinds of things. That's all allowed in a way that it's often not in, like, in if you're running a program in government, you might not be able to collect people's personal information to do some of that stuff, but in health you probably are. Again, my disclaimer applies at the beginning.
Fair enough. Educational purposes only, not legal advice. Okay, so I think we're at the end of our time. If anyone, maybe if there's any really pressing questions, maybe Andrew, you could take one more, but if not, I think we can wrap it up.
It's been a pleasure. I just wanted to say, like, we do offer, we're reorganizing our website. It's hard for even me. I've worked here for a year and a half. I find it difficult to find things, but there is a lot of information available that we've produced over the years around some of these topics. I'd welcome your visits to our website. These are the sorts of questions we talk a lot about in documentation, as well as, we also have, the commissioner has a blog and a podcast around matters related to personal information, personal health information access and privacy. And there's a lot here, far more than I could talk about. And it has been a pleasure to talk to you, and I hope this has been useful for you.
Yeah, really appreciate it, Andrew. It's been really informative. I see a lot of comments saying the same thing. I'm really impressed with the turnout as well. We've had 31 people on and off the call. So really appreciate it and hope it was insightful for all those on the call.
Thanks very much.
Yeah, thank you too. Thanks, everyone.